Exiting a contract without incurring penalties can be a complex task, but it is possible under certain conditions. Understanding the terms of your contract and exploring valid legal grounds for termination are key steps. 1. Review the contract terms. A. Termination Clauses. Early termination clause. Check if the contract includes a clause allowing for early termination. This may specify conditions under which the contract can be ended without penalties. Cancellation Policy. Look for any stated policies regarding cancellation, including notice periods and requirements. B. Breach of contract material. Breach. If the other party has materially breached the contract, failed to fulfill their primary obligations, you may have grounds to terminate the contract without penalties. Minor breach. Even minor breaches can sometimes justify termination, especially if they are persistent. 2. Evaluate legal grounds for termination. A. Mutual agreement negotiation. Discuss the possibility of mutually agreeing to terminate the contract. Both parties can negotiate terms that are mutually acceptable and sign a termination agreement. Written confirmation. Ensure that any mutual agreement to terminate the contract is documented in writing and signed by both parties. B. Impossibility of performance force majeure clause. Check if the contract contains a force majeure clause that allows termination due to extraordinary events beyond control, e.g., natural disasters, war. Legal impossibility. If fulfilling the contract has become legally impossible, you may be able to terminate the contract without penalties. C. Frustration of purpose. Change in circumstances. If the original purpose of the contract is no longer attainable due to unforeseen changes, you may invoke the doctrine of frustration. This legal principle allows for termination when the fundamental reason for entering the contract has been undermined. D. Misrepresentation or fraud. Misrepresentation. If you entered the contract based on false statements or deceptive information provided by the other party, you may have grounds to void the contract. Fraudulent inducement. If the other party intentionally deceived you to enter the contract, you can seek to exit the contract without penalties due to fraud. E. Violation of public policy, legality. Contracts that involve illegal activities or violate public policy can be voided. If the contract involves any illegal provisions, you can terminate it without penalties. 3. Consult legal counsel, a professional advice. Legal review. Have an attorney review the contract to identify potential grounds for termination and advise on the best course of action. Representation. An attorney can help negotiate with the other party and draft termination agreements to protect your interests. B. Dispute resolution mediation. Consider mediation as an alternative to litigation. A mediator can help both parties reach an amicable solution for contract termination. Arbitration. If the contract contains an arbitration clause, use arbitration to resolve disputes related to termination. 4. Document all communications. A. Written notices. Notice of termination. Provide written notice to the other party, clearly stating your intent to terminate the contract and the grounds for termination. Follow contract protocol. Adhere to any notice periods and procedures outlined in the contract. B. Record-keeping documentation. Keep copies of all communications, notices, and agreements related to the termination. This documentation can be crucial if disputes arise later. 5. Negotiate a settlement. A. Compromise solutions. Settlement agreement. If outright termination without penalties is not feasible, negotiate a settlement agreement that outlines acceptable terms for exiting the contract. Compensation. Offer to compensate the other party for any reasonable losses or provide alternative solutions to fulfill their needs.